Today's topic is, can I get my felony assault case reduced to a misdemeanor? If you've recently been arrested for a felony assault, or if you're just interested in this topic, stick around. I think you're gonna like this video. My name is Dod. I've been a criminal defense attorney here in San Diego since 2004. My firm is Dod Law. We focus exclusively on criminal defense cases, as I have since 2004. I've handled over 7,000 criminal cases in my life. Today's topic, what happens on a felony assault case in San Diego? Can you get it reduced to a misdemeanor? We get these cases all the time. The common example is a fight at a bar in PB or Ocean Beach or downtown. Remember, we're a huge college town. We have several colleges and universities. We have several law schools, several junior colleges. We are a vacation spot. We have a lot of bar fights. So the typical example is a bar fight where somebody gets injured and now you're charged with an assault with a deadly weapon. And when you see the term assault with a deadly weapon, everyone says, well, Dod, I didn't use any guns, any knives, any other weapon. I get it. Sometimes they just say your fist or your feet, were the deadly weapon. So the common example, a fight at the bar, somebody gets injured, they break a bone, they have a concussion, something happens, you're arrested, now you're facing felony assault charges, you were booked into jail, you posted $50,000 to get out, and now you're facing felony charges and you're looking for an attorney, and you are concerned that you might lose your job, that you might get kicked out of school, that this is going to affect you in the long run. Now, let me be very clear. Your case will depend on a variety of factors. Number one, your case is going to depend on the injuries. What are the injuries here to the alleged victim? How did the fight start? Who started the fight? Do you have a viable self-defense claim? For example, did the other person come at you first, threatening you, and you were in fear of imminent bodily harm? That's why you did what you did, and that's why, they have their injuries. Do you have a defense? What have you done since the incident to help mitigate your case? If you're at a bar, chances are you were probably drinking, you were probably drunk, the alleged victim was probably drinking and drunk. Are you taking this seriously? Are you doing AA classes? Are you doing anger management courses? When we get a case where we have injuries, but the injuries aren't too severe, there is a possibility that we can get the case reduced to a misdemeanor as long as our clients are proactive. They're doing AA classes, they've done anger management classes, they are working or going to school or both, and they get several character letters. Then your attorney would put together a mitigation packet and present that to the judge, present that to the DA, and remind the prosecutor that we might have a self-defense claim. So if we went to trial on this case, there is a good possibility that a jury could find you not guilty. And based on everything that you have done, they believe that this case should be reduced to a misdemeanor. The injuries aren't too severe, therefore the case could get reduced to a misdemeanor. Now, what happens if the injuries are pretty severe and they've hit you with an allegation called a gross bodily injury allegation? Now, that gross bodily injury allegation will make your case a strike. It is very unlikely in that type of case that you're going to get your case reduced to a misdemeanor. You still need to do everything that we just talked about, AA, anger management, character letters, work, school. You still need to do all that in hopes that your attorney can work out a deal where they dismiss the gross bodily injury allegation and have you just plead to a felony. Or if the injuries are just so severe that they're not going to reduce the case from the gross bodily injury allegation to a straight felony, everything that you've done up to that point will help your attorney try to convince the judge and the prosecutor to give you probation and not prison. Because if you're charged with an assault with a deadly weapon with a gross bodily injury allegation, potentially you're facing prison time. So everything you're doing to help mitigate your case can get your felony strike to no prison time, probably probation. You can do work furlough, you can do CPAC, you can do other alternatives to jail. Whatever you've been doing to mitigate your case can get the allegation dismissed, where you're just left with a felony. And then later on, you can come to court and have the court petition the court to reduce your case to a misdemeanor. Or if you've done everything up front and the injuries aren't too severe and the prosecutor isn't convinced that they have a good case to go to trial, they could just give you the misdemeanor right off the bat. So continue to do what you're doing if you're charged with a felony assault. Consult with your attorney. This is not legal advice. I advise you, it's a great idea to be proactive in any criminal case, especially a felony assault. If you like this video, hit the like button. You can subscribe to our channel. If you have any questions, please give us a call. I've been handling these types of cases for a very long time. I specialize in these types of cases. We're in San Diego County, where we get these cases every single day. Give us a call if you have any questions. Do not stress out. Thank you. Have a great day.